Mic test.
Mic test.
Good morning, ladies and gentlemen. This is the County of Santa Clara's Federal Affairs Advocacy Task Force, and we are set to begin at 10 o'clock. That time has arrived. The task force consists of two members, Supervisor Otto Lee and myself. I am County Supervisor Joe Simidian. Supervisor Lee is here. He has stepped away for just a moment. When he returns, I will turn to the clerk and ask that we call the roll and bring the meeting to order officially. Bear with us for just a moment or two. And speaking of, we will ask the clerk to call the roll, please.
All right. Vice Chairperson Lee.
Good morning, President.
And Chairperson Simidian.
Present. Thank you very much. We'll call the meeting to order. A quorum having been established, both members of the task force present. And the first item on our agenda is public comment. Public comment is that portion of our agenda which is set aside for comment by members of the public on non-agendized items that are properly within the jurisdiction of this task force. Let me turn to the clerk and ask first, do we have any speakers here in chambers, Madam Clerk?
We currently do not have any requests to speak, whether in chambers or virtually.
I see. Thank you very much. All right, then that allows us to move on to item number 3, which is to approve the consent calendar and or change it and see if there are any changes to the task force agenda. Supervisor Lee, the only item on our agenda for consent is the scheduling of the next meeting pending Board of Supervisors approval of an extension of the task force. Would you like to offer a motion at this time?
Yes, so moved.
All right, Supervisor Lee moves the approval of the consent calendar, and I will be happy to second that. Let me just confirm with the clerk, no speakers on this item?
No speakers for this item.
All right, call the roll.
All right. Vice Chairperson Lee.
Aye.
And Chairperson Simidian.
Aye.
Thank
Motion is
you.
approved, and the consent calendar is approved as submitted in our published agenda, which takes us to item number 4, which is verbal reports from the chair or vice chair relating to items of interest to the task force. Supervisor Lee, anything you'd like to share?
We now have a House Speaker, I heard. But other than that,
We'll hear a little bit more about it, but thank you for that breaking news. I have nothing additional to share. I want to save time and get right into the reports from our folks at Prime who are visiting with us today, and we're pleased to have them here. So let me just say, can I get a motion to receive the verbal reports, albeit brief?
so moved.
Motion by Lee, second by Simidian.
Okay. I'll call the roll. Vice Chairperson Lee.
Aye.
And Chairperson Simidian.
Aye, and I assume that means we had no speakers on that item as well.
That is correct. No speakers.
Thank you, just for the record. All right, that takes us to the heart of our business today, which is to consider recommendations relating to items of interest to our task force. And first is to turn to County Council, who has a couple of items, I think, that you want to update us on. So let me turn to Mr. Press and see what you have to share. Thank you.
Yes, good morning, Chairperson Simidian, Vice Chairperson Lee. 3 items I was asked to speak on. One is the status of the Alliance for Hippocratic Medicine versus FDA mifepristone litigation. You recall we've talked about this a few times in this task force. There's a line of cases making their way through the federal courts challenging the FDA's more than 20-year-old approval of mifepristone. In April of this year, the cases from the 5th District made their way to the U.S. Supreme Court, and the U.S. Supreme Court issued a stay essentially on all of the lower court rulings until the U.S. Supreme Court either grants cert on any subsequent decisions and or declines, in which case we would have to see what the state of the affairs was of the final rulings. What's been happening in the interim is that after coming down from that Supreme Court ruling and stay, which means that mifepristone is legal everywhere in California the same way it was to the same extent prior to these lawsuits, and available the same way around the rest of the nation the same way it was prior to these lawsuits. It went back to the 5th District Court of Appeals. They issued a split decision that was not very different from an earlier decision where they said the original approval of mifepristone was reversed, the injunction against that. So in other words, mifepristone generally was still available, but that some later changes to dispensing requirements and a relaxing, frankly, of dispensing regulations, that those would remain enjoined. Now, again, that injunction, that order, has no effect at this point because of the Supreme Court's order from last April. That is now, that Fifth Circuit Court of Appeals decision is now making its way back to the U.S. Supreme Court. And at this board's direction, we have filed another amicus brief, joining with some other large local governments and municipalities, the County of Los Angeles, City and County of San Francisco, King County in the state of Washington, as well as Cook County, Illinois. So those are some pretty large and populous areas from around the nation. So briefing is still occurring on that latest petition for certiorari, so we do not yet know if the Supreme Court will take the case, and if so, when they will calendar it.
Thank you. Let me just very quickly ask, because I want to sort of take us to where we are right now. So right now the case sits where?
Right now it is, well, that's an interesting question. It's sort of in between. I would put it this way. Right now it sits with the Fifth District Court of Appeals because the Supreme Court has not yet decided upon the petition for certiorari, which is still being briefed. So technically they have not, if you will, divested jurisdiction from the Fifth Circuit.
And the Fifth Circuit's disposition on the case thus far is?
The split decision of finding that the original FDA approval of mifepristone was lawful, but subsequent dispensing relaxation regs should be, in its view, enjoined or stopped.
And if the higher court, the Supreme Court, does not take the matter up, will that in fact be the outcome, quote unquote?
Yes.
And in practical terms, and if you don't know, because it's not a legal question, but in practical terms, what would that more rigorous set of expectations, less relaxed set of standards mean to folks who were trying to acquire mifepristone?
It would mean that we would essentially return to the state of affairs as they were in, I forget the exact year, but 2014, 2017. In other words, before there were these relaxations to the dispensing, and also, if I recall, during that time, there were changes to when mifepristone could be used. So remember, it's a two-drug regime, so misoprostol is still available. But it would basically turn the clock back on the clinical practice by a number of years.
I think what I'd like to do is ask, as we go forward in the conversation today, if there's anyone here who can speak to what the sort of practical implications of such a rollback would be in tangible terms. That would be helpful information. And if not, since we're not really the Health and Hospital Committee here today, then Mr. Campos, I would ask that we get an off-agenda memo from whoever the appropriate source is, and that we identify who at our Health and Hospital Committee meeting would be the appropriate person to ask that question, for, to whom we would ask that question. All right. Ms. Press, thank you. Let me go to Supervisor Lee on that matter before we let you march through the other two items I know you want to report on. Nothing else? Thank you. Go right ahead, Mr. Press.
Sure. So the second item is you asked for an update on the Mental Health Parity and Addiction Equity Act proposed regulations that are still in the what we call the notice and comment phase. So the proposed rule was issued a few months ago. The comment period was open until October 2nd. Over 10,000 comments were received to these proposed rules. We surveyed them, took a look at them. Of course, all folks across the spectrum, regulators, advocates, payors, interested parties. There's quite a bit of material in the record. We felt that we didn't have frankly, a whole lot to add to the conversation after those 10,000 comments, so we did not, as a county, submit our own comments. So right now, the FDA, or rather, I'm sorry, HHS, IRS, and the Department of Labor, all the federal level, are now digesting those comments, and depending on what they do, they could revise the proposed rule, or they could respond and then publish a final rule. As you can imagine, I know you had asked about the effective date last time. The current version of the proposed rules sets a January 1st, 2025 effective date. As you can imagine, there were advocates that suggested that the effective date should be advanced to 2024 sometime, and there were others that requested that the effective date be pushed out to sometime in 2026. So that is also still up in the air. But at this point, there's no new language in the proposed regs yet. We just have not yet heard back from the federal government as to how they're going to respond to the 10,000 comments.
And just to be clear, because we're jumping back and forth a little bit, and forgive me if I lost track, we're talking about the Mental Health Parity and Addiction Equity Act comments?
Correct. And to the comments to the proposed regulations to further implement that federal law.
And let me just, and I really do mean this as a question, and there's no implied critique here. Notwithstanding the fact that there were 10,000 comments, rare is the occasion when the County of Santa Clara doesn't have something else to add or say or weigh in on, just given the fact that each jurisdiction truly is unique in its circumstance. So I'll ask the question a little bit rhetorically. Really, there was nothing where we thought we had a slightly different point of view or set of interests or needs?
That was the feedback that I heard, and at the same time, it's not necessarily a requirement, but you want to, it's sort of the better practice to make sure that certain arguments are included in the comments if you want to later challenge the rule. Not quite sure, frankly, if the county even wants to challenge the rule.
Let me ask and let me tell you where I'm headed,
Sure.
which is the effective date of the rules, so
Right.
you understand why I'm poking at you here. Has the time for comment closed?
Yes, October 2nd.
Is there any way, notwithstanding the fact that the time for comment is closed, that we can weigh in exhorting a earlier, sooner rather than later date?
I don't believe that would be considered part of the record at this point if we were.
Is there any way to influence that outside of that process?
I'd have to think about that. I'm not sure if that's possible.
Can I ask you to give us a report back, off agenda, confidential or not? Supervisor Lee, it won't surprise you because we've had this conversation before on Mental Health Parity and Addiction Equity Act. If I remember correctly, Mr. Press, we're talking about a conversation that's gone on for 25 years with subsequent legislation, which begs the question, at what point do we start to take this seriously and really address the issues? And I know I don't need to persuade you on this, but if there is a way to add one more voice to the choir that says, could we please get at it, I would like to do that. So that's my personal take on the subject. Supervisor Lee, anything on this one? Nope. All right, then let's turn again to Mr. Press for his next report.
All right, the last one, and forgive me, this is going to take a little bit of time to roll out.
Won't take 25 years, so
No, will not take 25 years. Fair enough. Although this is a 40-year issue in the making. This is about a case that is currently before the Supreme Court called two cases, but the lead case, if you will, is called Loper Bright Enterprises versus Raimundo, the Secretary for Commerce, and then another case, related case on more or less the same issue called Relentless versus Department of Commerce. And what this case is about, and you'll see when I get into some of the facts, it's kind of a curious set of cases, but they are expressly seeking to challenge and overturn a 40-year-old case called Chevron versus Natural Resources Defense Council. This is a 1984 case that many administrative law scholars describe as the most talked about, most written about, most cited administrative law decision of the Supreme Court ever. So because this involves administrative law, which is, frankly, an upper division law course in most law schools, and I'm assuming that members of the general public are not necessarily steeped in the fundamentals of administrative law, I want to spend a little bit of time of just sort of setting the table as to what are we talking about so that we can appreciate why Chevron is significant and why overturning it would be significant and what might happen. So first, just to sort of set forth what did Chevron, this nearly 40-year-old Supreme Court case, decide. And this is a Supreme Court decision. They articulated this test, and what they said was that, in essence, anytime there is some type of gap or ambiguity or even silence in a statute about a particular topic, then the federal agency that Congress has empowered to implement that statute, if that federal agency finds a policy or other way of interpreting that gap, that silence, that ambiguity, and usually which is done by federal regulations, if that's a reasonable way that the federal agency went about it, then courts should defer to that federal agency interpretation of law. So again, first an ambiguity, and then the ambiguity filled in with usually a federal regulation. So why is that important? So, and again, this implicates things like the parity regulations. So just to talk about basic fundamentals of how a regulation comes into effect. So first, there's an enabling law where Congress says, here's an issue. Obviously, there's some detail that needs to be spelled out. We're going to empower this particular federal agency with the authority both to implement the law and to promulgate implementing regulations. The agency then starts to do that. They publish a notice of proposed rule. There's notice and comment, which again is that phase is precisely where we are with the Parity Act regulations. And then after considering all the notice and comment, the final rule is promulgated, an effective date is chosen. And again, as we can see from the chart that we submit with the ledge file for this matter for each federal affairs meeting, there are many, I would say probably even a majority of the matters in that chart, cases where the county is either a party or is filing amicus briefs on relate to federal regulations. So this is kind of a vital issue for us in terms of our interests. And so then bottom line is the federal regulation comes out and hopefully speaks to some of these gaps or details that were not addressed in statute. So you might ask yourself, well, why is that even necessary? Why doesn't just Congress fill in all the details? Why do we need to have regulations? And I'll give you a few examples, an old one and a relatively recent one, all things considered. So a very old one, in the Postal Act of 1792, yes, we go back that far, the Congress gave the Postmaster General broad discretion where to set up post offices and also the authority to contract with different ways of delivering the mail. Now, frankly, that is not something you would want to waste Congress's time with, figuring out each and every address. Similarly, a more recent example, the National Labor Relations Act, Congress explicitly left the work of applying the Act's general language, quote, in light of the infinite combinations of events which might be charged as violative of the Act's terms. So again, many different scenarios as to when the labor relations laws would apply to hundreds of thousands of different employers, millions of different employment circumstances. Congress said, NLRB, you are tasked with filling in all those details as to how to meet the goals of our statute. Other federal statutes talk about the setting of rates for all sorts of different things, with the exhortation that the rates be just and reasonable. Again, leaving it to the agency to figure out, usually in consultation with industry and advocates, what does a fair rate look like. So this gap filling on details is, as some legal commentators described it, quote, an inevitable incident to legislation on complex subjects, unquote. So now we get to the controversy and where Chevron plays in this. So this wasn't really a controversial issue for perhaps the first 150 years or so of this nation. After the New Deal and World War II, though, the administrative state grew substantially, and likewise the number of federal regulations grew substantially, and the criticisms of those that increasing federal regulation followed. And so, not surprisingly, there were more and more challenges to federal regulations as to whether they really were something that Congress had envisioned or intended, or whether they went beyond the permission or the delegation, as we say, that Congress gave to a particular administrative agency. So that's where all these challenges came from. So let me talk about Loper Bright Enterprises versus Raimondo. Sorry.
And as you do that, if you could sort of highlight, underscore why we care.
We'll get there.
Thank you.
That is where this is all going. So, like I said, there's a lot of little things here where I'm trying to set the table. But we will definitely get to that.
I'm ready to feast, Mr. Press. Thank you.
Well said. So, in this case, Loper Bright Enterprises versus Raimondo, and again, you will see this is kind of an interesting but also curious case that is going to the Supreme Court that potentially, I would even say likely, will lead to the overturning of Chevron. This is about a case from a federal statute from 1976 called the Magnuson-Stevens Fishery Conservation Act. And in that act, it asked that the Secretary for Commerce develop fishery resource management plans, and these apply all around the nation. And here's the issue that came up relatively recently. There was this issue about this. The statute allows observers or people to make sure that there's no inappropriate bycatch during fishing, that there's a requirement in the law that vessels that go out to sea are obligated to carry observers so that they can watch what the fishers are doing. The law was silent on who paid for them. So the National Marine Fisheries Service, delegated by the Secretary for Commerce, said, we are deciding that in this particular fishery in the North Atlantic relating to herring, that fishery, they should actually be obligated to pay for these observers to go on board their vessels when they go out to sea. And they actually did some financial projections and found that that would cost on the upper end up to $700 per trip. So not surprisingly, some commercial fishers who are a part of that Atlantic herring fishery business or industry sued. And among other things, they said that this Chevron way of evaluating cases should be overturned. So let me explain what happened. So Chevron, what the court said in Chevron, it's a two-part test. Part one is the court says, did Congress speak to this issue? Relatively fairly straightforward statutory interpretation question that courts do all the time. In this instance, the least the appellate court said, we think it's unclear. There's different mentions about observers and who pays and what should be paid and was that meant as a limitation, et cetera, et cetera. So the court said it's not exactly clear if in this instance funding of the observers was contemplated by Congress. So then they had to go to part two, which is, was it reasonable what the National Marine Fisheries Service did here? And in this instance, the Intermediate Appellate Court, the D.C. Circuit, said, yes, we think that is reasonable, what they did, to make industry pay for the observers. So that was the two-part test from Chevron. First, is there an ambiguity? Second, was the agency's interpretation reasonable? So what they are asking, what Loper, Bright, and Relentless, the two litigants, are asking in their cases that are now before the Supreme Court and calendared for argument in January, is basically, can you please overturn or dramatically narrow this Chevron decision or analysis, in the sense that if it's not clear from the statute, the argument goes, then the agency is not empowered to essentially legislate, that instead maybe it should go back to Congress and Congress should re-articulate what they really wanted. So that's in a nutshell, that's sort of the debate that is pending before the Supreme Court. As it happens, as I noted earlier, Chevron is a very much criticized, commented upon Supreme Court decision, just based upon recently articulated statements by at least 4 members of the Supreme Court, who would be Roberts, Kavanaugh, Gorsuch, I think Thomas. They are all very, very critical of Chevron as a judge-made rule, so to speak. Wouldn't be surprised if Justice Alito joined them. So even without knowing where Justice Barrett might stand on it, you've got 5 votes right there. So I think a lot of observers are expecting Chevron to be overturned, but we'll have to see when the argument occurs in January. So now, the table is set, now we can feast. Why do we care? What does this mean for California? So practically speaking, Chevron, the two-step analysis, the whole line of jurisprudence, it only applies to the interpretation of and the challenges to federal regulations implementing federal statutes. So right out of the gate, this does not apply to state regulations, local government administrative ordinances or guidance. So that is not affected by Chevron. And in fact, we in California have our own rule about when and under what circumstances to defer to administrative agencies that I would contend is a little bit more stringent than Chevron. So even our own analysis as to how we go about that probably would not be changed. What's also not affected is that federal courts aren't really, frankly, interested in what state or local entities feel about federal regulations. In other words, there's no deference. Certainly if we can make persuasive arguments, but there's no sort of U.S. Supreme Court command for deference to a state or local government interpretation of a federal regulation. So that kind of confines the impact, but the effect that it would have is it would, frankly, make challenging federal rules easier, because federal agencies would, frankly, have less leeway. There wouldn't be this Supreme Court command to say, hey, if there's an ambiguity or a gap in a statute and the federal agency's interpretation is reasonable, courts, you should defer to that. As I said, that deference, Chevron deference as it's called, would be absent. So what that means is that Under a prior federal administration, we would have had an easier time to challenge regulations. Under the current administration, challengers will have an easier time. So it really does depend on the administration and what, frankly, policies that administration is pursuing. It will mean variously. Well, in general, it will mean an easier time for all to challenge those federal regulations in court. And some have argued it will make federal agencies, frankly, less reluctant to promulgate federal regulations.
So to your last point, if the Chevron standard is set aside, that will be, excuse me, that will be problematic if we like the role the federal government is taking, and it will be potentially beneficial if we don't like the role the federal government is taking.
In regulations, exactly, yes.
And reminder, at least for me, our board, our county has not weighed in on this matter thus far. We're simply, or is this one of those areas where I'm simply not recalling that we did provide some direction or that the office took initiative to weigh in?
I don't believe we've weighed in on this. Yeah.
Any notions about whether we could or should?
That's an interesting question. We'd have to, I think we would
Look
want to
forward
discuss
to
that.
an interesting answer at a subsequent meeting. I'll
Sure.
be curious. Thank you. Supervisor Lee, questions on this item? I did not think that the Postal Act from 1700s would be on today's conversational agenda, so let alone herring, which, thank you.
I'm trying to understand the impact of this is if this were set aside as mentioned in Chevron doctrine, does it mean that these administrative agencies would be less empowered, meaning that courts actually will have more powers to kind of rule whichever they want? So you might have different interpretation of these gaps by different courts all over the country of these federal laws.
Yes, I think that is exactly the argument. In fact, some of the critiques of Chevron is that it frustrates Marbury versus Madison. And again, for all of you looking for free MCLE credit, Marbury versus Madison is the foundational case about judicial review in this country, that it is the province of the courts to say what the law is. And so some contend that when there's a judicial command to say, well, we're going to defer to an agency's interpretation, that frustrates Marbury. I don't agree with that criticism, but that's sort of the argument, that take out that deference and it keeps it all within the courts.
Okay, that's all I have. Thank you.
All right. Anything else on this item, Mr. Press? Thank you. Let me check with the clerk. Do we have commenters on this item?
There are currently no requests to speak, whether in person or virtually.
Thank you very much. Supervisor Lee, that means that the appropriate motion, I believe, is simply to take the recommended action, which is to receive the reports.
Yes, so moved.
Motion by Lee, second by Simidian. Call the roll.
All right. Vice Chairperson Lee?
Aye.
And Chairperson Simidian?
Aye. Thank you very much. Motion passes unanimously. All right, that takes us to item number 6, and both of the County Executive's Office and our representatives from Prime Policy are here to tell us what on earth is going on.
Thank you.
Campos, go to it.
Thank you very much, Mr. Chairman, Mr. Vice Chair, David Campos, Deputy County Executive. I feel like I'm brought back to civil procedure in law school. Any reference to the Postal Act into 1792 and Marbury versus Madison, so very informative. I simply note that it was important for the county executive and for me, as I'm taking over the role of overseeing the legislative affairs of the county, to make sure that we heard directly from the folks that are representing us in Washington, D.C. And so we are grateful to Prime Policy for making themselves available today. I also want to thank Danielle Christian and as well as Elaine Trin and Gracie Sanchez for helping to make this trip possible. And I'll just turn it over to them so that they can give you a brief overview of what's happening in Washington, D.C. And I will simply note two important things. In the last day or so, we have been meeting with Prime Policy and the leadership of the county, with the administration, but also members of the Board of Supervisors. And one thing that we hope to do in the coming year is to actually have a delegation go to Washington, D.C., and look forward to to having input from members of this committee on that. So with that I will turn it to Mr. Mead.
Thank you, Mr. Campos, and Chairperson Smithian and Vice Chair Lee. Was glad to be here in person to deliver our report. Let me just start with a little bit about the drama that's happened in the House.
Forgive the interruption. If I could ask the clerk just to lift the volume up a little bit, unless we're at max volume, and I've already encouraged the speakers to lean in, just like I should be leaning in right now. So, okay. Thank you. Go right ahead, Mr. Mead. Don't worry. Don't overworry it. It's the nature of our system.
Hopefully this is a little bit better now.
There you go.
But I'm going to cover the drama that's happened in the House of Representatives, and then talk a little bit about what's happening with the appropriations process. And then my colleague, Ms. Powell, will talk about the expiring provisions, and Ms. Storton will follow up with some specific. I'm sorry, I've got the order reversed. Ms. Storton will go first about the specific projects that you have in the appropriations bill, and then Ms. Powell will talk about the expiring provisions. So on October 2nd of this year, Congressman Matt Gaetz from Florida filed what's known as privilege resolution to vacate the office of the Speaker, thus terminating the speakership of Congressman Kevin McCarthy. That is considered a privilege resolution, meaning that the House of Representatives must turn to it immediately and can't consider any other business until they dispense with that. And on October 3rd, the House began consideration of that resolution, and the allies of Speaker McCarthy tried to offer a motion to table that resolution, but that was defeated by a vote of 218 to 208, thus allowing the House to consider the resolution to terminate Kevin McCarthy's speakership. And that passed the House on a vote of 216 to 210, with 8 Republicans joining 208 Democrats to terminate Kevin McCarthy's speakership. And I'll just note that no Democratic members voted to keep Speaker McCarthy in office. However, we are told that several Democrats were willing to either not vote on that motion or vote present, thus allowing Kevin to have enough votes to remain in the office of Speaker. But two things happened with Kevin McCarthy. One is he wouldn't engage with or talk or meet with those Democrats who are willing to help him out on the vote. And secondly, he went on national TV over the weekend before this vote and basically accused the Democrats of wanting to shut down the government. And so the combination of those two things led every Democrat to vote to terminate his speakership. And the, Congressman Gaetz cited the fact that Speaker McCarthy put on the floor on September 30th over the weekend a continuing resolution to keep the government open, which had the support of 126 Republicans, the majority of the conference, but had 90 dissenting votes. And Congressman Gaetz sort of accused Kevin McCarthy of working with the Democrats to keep the government operating, and used that as a basis of his quest to terminate his speakership. However, all of those representatives who voted against Kevin McCarthy had personal grudges against Kevin. For example, Ken Buck from Colorado lost his chairmanship on the Judiciary Committee. The chairman, the subcommittee had a jurisdiction over over the big tech companies, and Congressman Buck had legislation that he worked for on a bipartisan basis to go after these big tech companies. And Speaker McCarthy didn't like that because he had been cozying up to these companies to try and get fundraising money from them. And so Congressman Buck was mad because he lost his chairmanship of the subcommittee. Another member from Virginia was mad because he defeated an incumbent Republican congressman in a primary, and Kevin never called to congratulate him on his win. Well, he knocked off one of our incumbents, and Matt Gaetz himself blamed Kevin McCarthy for the Ethics Committee investigation into his affairs. Kevin wasn't driving that. The Ethics Committee took it upon themselves to investigate Matt Gaetz. But nevertheless, they voted to terminate his speakership, but they didn't really have a plan B or backup to who else would be speaker. And so at first, the House Republican Conference nominated Steve Scalise, who's the current majority leader, to be the speaker. But Steve realized that he didn't have 217 votes on the House floor to become speaker, so he backed down. Then they voted to have Jim Jordan from Ohio, who chairs the Judiciary Committee, to be the nominee for the speaker. And Jim Jordan took his nomination to the House floor and had 3 votes on the House floor. Each time he received less and less votes for him to become speaker. And one of the reasons why was that a lot of outside groups were intimidating members who wouldn't vote for him and actually threatening them with violence. And he didn't really back them down, or all he said was, well, if you're worried about a threat, just vote for me. And so that wasn't a good path to get to 217. And then finally they nominated Tom Emmer, the current House whip, to be the speaker nominee. But Emmer, the moment after his nomination, Roger Stone tweeted, "Why would we make Tom Emmer the speaker? We should just go back to Nancy Pelosi. There's no difference." And that was not a good sign. And then former President Trump tweeted against Emmer, and that just killed his candidacy. So then the Republican conference turned to Congressman Mike Johnson from Louisiana, who's serving as he was elected to serve as the vice chairman of the Republican conference. So he was in the elected leadership, but really at a very low level. Mike Johnson's very, very conservative, but the Republicans were willing to go along with them, and I think there's sort of 2 reasons for that. One is exhaustion. This dragging this out and having these votes, and oh, by the way, in addition to these votes for nominating, they had hours upon hours and hours of closed-door meetings where everyone's yelling at each other and trying to figure this out. And so they were willing to go along with Mike Johnson, even though he's very conservative. The other factor was that there was a number of Republicans who were threatening to work with the Democrats to empower Patrick McHenry, who is the acting speaker, to have the full authority of the speakership and run the House of Representatives for a period of time. And the thought of having a bipartisan vote for speaker really drove all the Republicans just to go ahead and support Mike Johnson. And as I mentioned, Mike Johnson's a very conservative. He has very conservative political views, but he's also very conservative in his activities. He doesn't really throw bombs. He's just very conservative. But he's a man of integrity, and people can take him at his word. And so that goes a long way. And in fact, we had breakfast with a Democratic member of the House who said just that. He came into the Congress with Mike Johnson, got to know him as a classmate, and that's one of the things that, when the incoming new members of Congress come together, it's called the freshman class, and those members do a lot together. They have projects, and they do a lot together. So he got to know him, and he said, he's very conservative. I don't agree with him on hardly any policy, but I know where he stands, and I know I can take him at his word, and that's that's a lot for a Republican speaker. So he was very complimentary of him. And I think the thing about Mike Johnson is he recognizes that he no longer is just, the congressman from the 5th District of Louisiana. He's now representing the whole House, and he knows he's going to have to, his personal views, he's going to have to set aside to allow business to go on. So, for example, he met with the Senate Republicans this week and told them he was willing to support a Ukraine aid package. He had previously voted against the Ukraine aid package, but now he's willing to support it, which I think is significant. And I give Mike Johnson credit because he has gotten back on track with the appropriations process in the House. They passed one bill last week, they passed another this week, and they're trying to pass 2 more this week. So he's trying to get that appropriations back on track. The thing of it is that his policies towards appropriations are no different than Kevin McCarthy. It's just that Kevin McCarthy had his dissenters, and he couldn't get a majority to move forward on his plan on appropriations because of all his enemies. But Mike Johnson's gotten that going again, and we do expect that the appropriations process will proceed, and it may be ugly at times, but we do expect that they're going to try to figure out and pass these individual appropriations bills. And I will note that the Fiscal Responsibility Act, which is the bill that increased the debt limit, had an incentive in it to pass individual appropriations bills, and they enforced that goal, that policy goal, with a sequestration of 1%. Now, that 1% sequestration doesn't kick in until April 30th of next year. So really, Congress has from now until April 30th to work out all these appropriations bills, and if they do that, they'll just turn off the sequestration. And I think there's an interest, I think both parties have an interest in avoiding that sequestration. Generally speaking, Republicans don't want the Defense Department hit by that 1%, and generally speaking, the Democrats don't want the domestic agencies hit with those 1% cut. So we're fairly optimistic that the appropriations process will yield individual bills. Ultimately, it's like I said, it's going to be messy to get from here to there, but they're going to work through it. And I should, two other things to know. One is that's good news for the county in that you have a few projects, and my colleague Ms. Thornton can get to specifics on your projects, but you have projects in one of the House bills. And so if the House can pass that in conference with the Senate, we're fairly confident your projects will remain in those bills. The levels and amounts may have to come down since the Senate doesn't have anything for your projects, but nevertheless, we hope that you can be successful in securing some federal funds from the appropriations process. The other thing to note is, there also, as I mentioned, the Ukraine aid. Congress is considering aid for Ukraine, for Israel, for Taiwan, and for our border. And Speaker feels strongly that the Israel aid should go separately and on its own. The House will vote on that, but ultimately, they're going to approve. Ultimately, Congress is going to approve aid for Ukraine, Israel, Taiwan, and the border. And whether it's in two bills or it all gets combined in one, we don't know. But it's going to go forward and it's going to get signed into law. So. Let me now turn to my partner, Ms. Thornton, to talk specifically about your projects.
And before you do, let me just say to Supervisor Lee, Supervisor, are you okay holding off on questions and comments until we've gone through the full presentation? Thank you for that. Ms. Thornton, nice to see you. Mr. Mead, thanks.
Hi. Good morning. Can you hear me? Great. So I just, in follow-up to my colleague, I just wanted to say that I think we've been through some of these appropriations items in the last meeting, but I just want to quickly reiterate them with sort of the lens that, as my colleague indicated, so these are all items that have made it into the House version of the bill, which is a Republican Congress. And the Senate, while they don't have these items in their versions of the bill, I think it's important to note that we're probably pretty safe as far as that some of these items will transfer over into the final bill with the Democratic Senate. So that said, in the items that I wanted to mention are that the county would receive $3.5 million for the Silicon Valley African American Cultural Center. That was requested by Representative Khanna. The county would also receive $2 million for emergency shelter and transitional housing for homeless veterans. Both, and whether this was a mistake or not, we don't know, but Representatives Khanna and Lofgren each submitted requests for $1 million, and both requests appear to have been included in the bill as it is now, so that it could end up being actually $2 million, or it could end up being cut to $1 million. We don't know how that exactly will play out, but the county would also receive $1,050,000 for the farm worker housing rehabilitation and electrification pilot program. Representative Lofgren requested that. The Santa Clara County Housing Authority would receive $850,000 for revitalization of the Buena Vista Mobile Home Park community, requested by Representative Eshu. And the Santa Clara County Office of Education would receive $500,000 for affordable educator housing in Santa Clara, and the requesting member was Representative Khanna. Now I'll turn back to my colleague, Ms. Powell, and she can give some update on expiring provisions.
Thanks, Aaron. Good morning, Supervisor Lee and Supervisor Simitian. As Rich mentioned in his remarks, Congress enacted a continuing resolution through November 17th. The measure included extensions for programs.
Ms. Powell, I'm so sorry for the interruption, but we do need a little more volume here.
We do?
Yep, thanks. Anything the clerk can do to help? Are we at full volume? All right, so it's all on you to boom it out. Thank you very much.
Okay. As Rich mentioned in his remarks, Congress enacted a continuing resolution through November 17th. The measure included extensions for programs that were scheduled to expire at the end of the fiscal year. Those would need to be included in the next CR or be included in individual appropriations bills. Those include the Community Health Centers Fund, the National Health Services Corps, the Teaching Health Centers / GME programs, a provision that delays the DISH cuts to Medicaid, the PREP Act, and TANF. Again, those were included in the CR that expires on November 17th, so they would need to be included in another piece of legislation as well, past November 17th. So several other programs also expired at the end of September, and those were not included in the CR that expires on November 17th. Those include the Pandemic All Hazards Preparedness Act, also called PAPA, the President's Emergency Plan for AIDS Release, PFAR, the Support Act, funding for child care, the media has also referenced that as the child care tax, the child care cliff, and the Farm Bill. Just close that out. Let's talk a little bit about the funding for child care. As part of the 2021 American Rescue Plan, Congress approved a total of $39 billion for child care, aimed at ensuring essential workers could go to work. The majority, $24 billion, was directed towards stabilizing child care centers and home-based daycares to guarantee they'd remain open and staffed. Those funds were for child care facilities to help them remain accessible and financially stable during the pandemic. They expired at the end of FY 2023. Last week, the White House proposed a supplemental bill. Included in the supplemental request for Israel and Ukraine was $16 billion earmarked for the child care sector. The $16 billion thought in this new request is equal to the amount that advocates argue is necessary to stave off the collapse of thousands of facilities across the country. Some House Republicans are pushing to split the request into two separate bills, one for Ukraine and everything else, and then one for Israel. At this juncture, the fate of the child care proposal is not clear. Also set to expire what also expired at the end of September is the Farm Bill. The Supplemental Nutrition Assistance Program, also known as SNAP and formerly known as food stamps, is the largest federal nutrition program, providing 41.5 million low-income individuals with monthly grocery benefits. The most recent Farm Bill that expired at the end of September included crop insurance, SNAP, rural development, and agricultural research and conservation programs. While the new Speaker has committed to a complete 5-year reauthorization of the Farm Bill, that would be difficult to get through the House. Speaker Johnson, more so than his predecessor, Speaker Kevin McCarthy, is a proponent of more hardline GOP efforts to overhaul the SNAP program. As a senior member of the conservative-leading Republican Study Committee, Johnson backed proposals to roll back food aid extensions under Biden and block states from exempting some work requirements for SNAP. Freedom Caucus hardliners and other Republicans are pressing to include similar measures in the next Farm Bill. Such a move would upend the fragile bipartisan coalition needed to pass the legislation, a blow to House Republicans who represent the majority of rural and farm districts, including Johnson, as well as more centrist GOP members who will be fighting for their political lives in 2024. However, if Congress pursues a shorter funding patch, it would likely push any floor consideration of a new Farm Bill into 2024. That would put the must-pass legislation, a major lift during normal years, squarely in the crosshairs of the presidential election cycle. We're going to continue to monitor developments around the child care cliff and the Farm Bill, and will keep you abreast of any new activity. This concludes my remarks.
Thank you very much. Mr. Campos, is it anything else you want to add? Anyone else want to pull in, or is it time for Supervisor Lee and me to lean in if we choose to do so?
I think it's time for your questions, Mr. Chairman.
Thank you. Supervisor Lee, I'm going to begin with you, please.
Yes, thank you, Chair. Yes, good morning. Thank you very much for the comprehensive report. Mr. Mead, I think the takeaway I have from you is that the continuing resolution issue looks like we can kick that thing down till end of April, given how things are looking.
Supervisor Lee, now I need to ask you to lean into your
Sure.
mic. Thank you.
So we are looking at probably April 30th and not have to worry about having to keep extending or having some type of a shutdown of the government and all that craziness.
So I would say that the prospect of a government shutdown is not zero, but is greatly diminished. Speaker Johnson has publicly stated that he wants to pass a continuing resolution that goes either till January or until April. But in either case, I think there's enough bipartisan support for a continuing resolution that we're going to see that happening. And part of his motivation for doing continuing resolution into next year is that it will likely carry with it the extensions of the programs Ms. Powell spoke to, and I think they want those to not have them expire at the end of the year and having to deal with them with the Christmas deadline. I think they want to push them into next year and deal with them at a later date. So we'll see what the Senate. We'll see what the Senate will accept from the House. It's quite possible that the Senate will just go along with whatever the House passes for a continuing resolution, just to keep the lights on and keep the government open.
Okay. The specific requests in this bill, are those basically specific earmarks that was requested by our various congressional delegations?
Yes, those are specific. The new name for earmarks is community project funding.
There we go.
And they're very specific parameters under which they can be applied for, and so that's what those are.
Great, thank you. And based on what you're thinking, is that most of it, if not all of it, probably will be all lumped into the bill to be passed eventually?
At least in some way, shape, or form, the amounts may differ here and there, but when they go to conference, the final bill, and as I noted, excuse me, the Senate does not have these items in their bill because we didn't our delegation, we requested them through the House members. But I think just given that they were included in a Republican bill essentially, and the Democrats control the Senate, I think it's safe to say that some pieces of it, unless there's some major change that we're not aware of yet, some pieces of those items will be included.
And I'll just add, the reason for our confidence that these projects will remain in the bill on some level is that the track record for the Appropriations Committee is that they have not kicked out any earmarks. If they were in the House or Senate, some level was kept in the final version of it. They may have adjusted the amounts of funding, but they didn't throw out anyone's projects as they conference these appropriations bills.
Great. So in that sense, I guess there's some silver lining of good news that these requests actually will eventually come through. May not be the whole thing, but some of it will come through.
Correct.
Great. Okay. Now, the other part of the bad news now about the we call it child care cliff that we're looking at. Is there any way we can quantify how much less money we will receive in this county when it comes to child care funding?
We can definitely look into that. We're not clear if this is going to remain on the cutting room floor or if it's actually going to move forward. I mean, the White House and Senate Democrats are pushing to get it done. It's just there's been so much back and forth within the last couple of days, honestly, in terms of whether Israel and Ukraine are going together, in terms of whether the speaker is going to support Ukraine. We're just not sure where this stands. We know that the White House and the president want to include it. I'm not sure where the speaker is at on it, but we can definitely look and see what the county was getting in terms of child care funding and what it won't get if this doesn't go through.
Yeah, I was going to say, we will look, the National Association of Counties, NACO, they may have an analysis of how much each county received from the previously appropriated child care money. So we can look to see if we can find that from them or other sources.
Great. And I'll basically ask the same thing about SNAP, how that might also affect us as well. I think from the county's point of view, we really need to know what that impact is. And if, if necessary, what type of readjustment of our funding we might need to make sure that these individuals not going to have that, those most vulnerable of our communities not going to be that severely affected. And for the parents to get the proper child care and not having, like you said, closing of the child care centers will be disastrous for community. Yeah.
Supervisor, we
Yes.
will provide just a follow-up memo on those two items. On SNAP, there's actually a political article on that talks about that issue brewing as a potential challenge to the new speaker. So,
Great. Thank you. And that's all I have, Chair.
Thank you. Let me apologize up front. I'm going to be bouncing around a lot because we went through the whole presentation. We have lots of different things. So I'll hop from subject to subject. First, Mr. Campos, actually, there was passing reference, I think, from you earlier about a potential delegation to Washington, D.C. Can you tell us a little bit more about what the conversation is around that possibility?
Mr. Chairman, that's in the beginning stages, but from my experience, our legislative efforts are always enhanced when you have participation by the elected leadership of the county. We have seen that happen at the state level and certainly at the federal level. And I know that it's something that has been done in the past, but it's been a while since that actually took place. And so we believe that it's important for us to pursue that, and especially in this climate, it's really important for us to maximize our voice and our presence, and that necessarily involves the elected leadership of the county being involved.
So presumably sometime in 2024.
That's correct.
All right. And I am not aware that, I mean, obviously COVID turned the world upside down in terms of these kinds of back and forths, but I'm not aware of any delegations from the Silicon Valley Leadership Group that used to have a fairly regularly scheduled set of delegations, in the last 4 or 5 years. Did I miss anything that you're aware of?
Not to my knowledge, Mr. Chair, and I can tell you that there are other jurisdictions. I know in San Francisco, members of the Board of Supervisors and the mayor do take those trips, and I think it's important for us to make sure that our voice is in the mix, if you will.
Got it. Thank you. Quick question about the earmarks, community project funding, and then just a little sharing of information. Is there a simple one-page list, and given all the information that floods all of us, it may well have come by me and I may have missed it, but is there a simple one-page list of the sort of county-related projects that's, do we have that? Is it available?
I can get it to you.
If you would,
Absolutely.
please.
No
And
problem.
I've got members of my office team who are here, but if you can just get it to us. And this is truly one of those times where less is more in terms of my request. Just bullet points. It's like this much for that much, and sort of make sure we have it all.
No problem.
Thank you. And I will just share with you all and with the county team and staff and Mr. Campos. Among a list of worthy projects, there's one that is particularly near and dear to me, so I just want to tell you it's particularly near and dear to me because I'm not sure that there's any reason that folks at Prime and certainly Ms. Powell, who's a little newer to the team, the $850,000, which doesn't sound like a lot of money for the Buena Vista Mobile Home Park in Palo Alto, is of interest and importance. And here's the quick backstory. This was the last mobile home park in the city of Palo Alto, which you may well know is a very pricey venue these days. In 2015-ish, it looked like the park was going to be closed and 400 very low and extremely low income residents, 85% of whom were Spanish speaking, were to be evicted from the property. Ultimately, our county and our housing authority and the city of Palo Alto were able to put together a rescue deal, purchase the property. The housing authority is now responsible as the owner of the site, and there's a major rehabilitation that is underway in an attempt to ensure that folks not only can stay in the community, but that they have a place that is safe and secure for what was at one time 117 households. It has taken longer than we all hoped, variety of reasons for that, but it's time, and I'm guessing you all have had enough experience, even if it's only tangential, with the federal government's role in the housing authority world to know that that can be a complex but also quite limited and rule-bound process. So having some funding that gave the housing authority and by extension the city and the county a little more flexibility is important in terms of the quality of lives to folks who are there. So I'll be tapping on your shoulders and in touch with you as we follow that one. I know Congresswoman Esch will keep us well informed as well, but I just wanted to give you a little bit of a backstory that it's a modest amount of money, but an important impact. Changing subjects dramatically, I was prompted by the conversation about Congressmember Buck, who I believe has just announced he's retiring. I'm trying to be more artful in my terms. You all have been at this a while. Let me try it that way. Big picture, broader question from the hyperlocal to the big picture, broader question. And if you want to take a moment to reflect, please feel free to do so. It strikes me that Washington has a somewhat different view of big tech these days than it would have 5, 10, 15, or 20 years ago. Would you agree with that assessment? And if so, what's that about in your observation?
Yeah, I'll start and let my colleagues.
Has obvious impact for, the growth and development of our economy right here.
Yeah, I'll start and let my colleagues jump in. It used to be that the big tech companies had a lot of goodwill in Washington, and I think you've seen that goodwill erode for probably a number of reasons. One is the content that a lot of these platforms are putting out, and there's a belief among many conservative members of Congress that the content is not balanced in terms of what is allowed to go on these platforms on the internet, and therefore they view them as kind of helping to promote democratic interests. And there's a issue around the last presidential campaign about what content could be on these various platforms and what couldn't be, and there's a view that it was biased. So that's one of the contributing factors to it. I think there's also a view that there's not enough transparency with what these companies are doing, and there's also a view of concern about how they handle individuals' information about them, and what are they what are they doing to monetize your personal interest, the searches you do, those sorts of things. And so and it's funny because I mentioned the conservatives' concern about content, but the other concerns are, I believe, are concerns that are held on a bipartisan basis. And so, again, their strong standing and sort of stature has definitely, in my opinion, been diminished significantly. Now, there are still some strong supporters of these platforms and these companies, but the number is a lot less than it used to be.
Others? Any? Feel free to weigh in. I think that was a pretty thorough comment, but I'm just curious.
I would add two other aspects as well: privacy and the effect on young people's mental health. There's been a lot bantered about bullying online and just the images that are online and how they're being received by younger people and how that contributes to overall mental health, aggressiveness, depression, fear of missing out, all of those sort of things. But, I mean, if you think about it, Congress loves a good boogeyman, right? I can remember a time some years ago when it was Walmart. Then it was pharma. Right now, it seems like the tech companies have landed in Congress's crosshairs. Sure, there are people that still support them, but they're getting a lot more criticism in the same way that pharma got it, in the same way that Walmart got it back in the day.
And if I could just add, as a father of 3 teenagers, the whole issue about youth, the content that youth can access on their phones is really scary, and you know, and you know, the CDC has even made recommendations about their mental health, about you need to take these devices away from teenagers and other children, at night. You can't let them take these to their room because that's just going to really harm them, their mental health. So that's a big issue. And again, that issue and aspect, I think, has bipartisan interest in that.
Thank you. This will make at least 2 of the 3 of you smile. What's going on with high-speed rail these days? See? 2 out of 3. Ms. Baldat, you're a newcomer to my interest and engagement on this, I think.
I am not well versed on high-speed rail at all. I will tell you that during my trips to New York, the Acela is not nearly fast enough. But aside from that, I have nothing intelligent to comment on high-speed rail.
Thank you.
So I would only add that I have noted that the California high-speed rail just received some federal dollars. But I have also noted, in going back through notes and through reading multiple things, that this has been an ongoing, I mean, to say the least, ongoing situation in California. And without the federal money, it may. I don't know what the trajectory is going to be, because this has been it's been a back and forth since.
Sure.
Jerry
Let me just ask you to, not today or tomorrow, but at some point in the foreseeable future, give us sort of your best 2 pages on here's what the future of federal funding for high-speed rail looks like, understanding that that's a little bit of tea leaf reading, but it would be helpful to get your sense of it as not only expert but independent analyst. We've got some significant decisions here in Northern California to make, and in Santa Clara County in particular. What's the prognosis for the Central Valley segment completion, and then will there ever be funding for a connection from that Central Valley segment to Silicon Valley by way of San Jose? Will there then ever be a segment that runs from San Jose to San Francisco? If so, where's that funding coming from? What's the likelihood? And again, here's the good news. I'm going to be termed out next year, so I can't hold you accountable 5 years from now if it turns out your best predictions were wide of the mark, which I think it's a very tough thing to know. We're 15 years into it, and I still think it's a hard one to read. But anything you can provide would be helpful and appreciated.
Will do.
Farm Bill. Could we revisit that just a little bit? Historically, I know from conversations we've had with you, the Farm Bill was the place where people could find bipartisan agreement because Democrats were looking at the SNAP benefits as an important component for folks in need, and Republicans were looking at it, and rural Republicans in particular, were looking at it as a way to provide some supports for folks in the ag world. And could you just tell us a little bit more about why it's hung up and what's hanging it up, and is there a path to a good outcome?
Let me start, and I'll let my colleagues jump in. A couple of comments about the Farm Bill, and I've had experience working on farm bills in my past, and it used to be that the Farm Bill had a provision wired into it that if it was allowed to expire, they had a provision in the law that would revert milk prices back to like the 1930s or something, and so the price of milk would jump sky high, and consumers would be outraged, and they would tell Congress, fix that and pass a Farm Bill. That provision got removed in the 1990s, so they don't have that hammer anymore to force consensus on the bill. And you're correct that, previously the coalition was that generally speaking, the more urban-oriented members like the nutrition programs, and the more rural members like the farm, support programs, and that marriage of the two allowed for bipartisan votes. The challenge is that now a lot of those rural members are pushing back on the nutrition program and want to see reductions or work requirements or other provisions put into them to make it to tighten up the eligibility for that program. And so that is splintering that coalition that previously existed. The current rumor is that the Senate chair and ranking member of the Ag Committee are looking to pass simply a one-year extension of the program to keep it going until the end of 2024, and with the thinking that, if there's a lame duck session after the elections, maybe they can work out a bipartisan deal during that lame duck session. But that extension is not guaranteed. It still has to pass through the House, and not clear whether the House would support that or not.
And keep in mind also, the Republicans have a 4-seat majority. So we can talk about redistricting and what may happen in the next election next year, but for now, Democratic votes are going to be necessary to pass the Farm Bill, to get it across the finish line. And you've got 4, maybe 5 New York Republicans that won they were elected in districts that Joe Biden won. So those are going to be more of your moderate-leaning districts. A farm bill that has work requirements in it is going to be hard for them to vote for. And you have some of the really conservative members who also may not vote for it. They may want more steeper cuts. So it's definitely going to be a challenge getting it across the line. I definitely don't think it happens this year. I think Rich is right. There'll be a one-year extension, and then we'll go from there.
You anticipated my next question, Ms. Powell. Thank you. The issue of work requirements is just from a political standpoint, one that has fascinated me for some time. I don't know if high in the sky, Mr. Margolin is with us today, I believe, yes?
I think he's via Zoom. I don't know if he's already on.
I'm on.
Thanks, Mr. Margolin. I'm going to revisit with our friends from Prime here a conversation that we have had previously, but I want to sort of wrap my head around this one again in a more current way. I think there is a certain simplicity to the argument that, well, if we're going to provide these benefits, why wouldn't we ask folks to step up and work for the benefits? And there then is pushback from particularly Democrats about, not really a thing. What's that back and forth about? And why do work requirements, why are they so key to the political debate, frankly, about this? Anyone?
I think the sort of divide is that there are many conservatives who view if we're going to buy your groceries, you need to either find a job or actively look for a job. So these work requirements, you don't necessarily have to be working per se, but you have to be actively seeking employment and applying for jobs and all these things, going through these motions. I think, from the other side of it is these are hungry people who need the nutrition. Why put up a barrier to having them get the benefit of getting this nutrition? We need to feed these needy people. So that's kind of the debate or divide. And it's funny because as part of the Fiscal Responsibility Act, they did introduce some level of additional they attempted to tighten up the benefits of the food stamp or the SNAP program, but in fact what they ended up doing was they actually expanded it in that law, and the CBO estimated that what they did in that law will actually cost more money. So, you know, the best intentions don't always work out.
I'm going to go to Mr. Margolin on this point in just a minute, but Ms. Dorton and Ms. Powell, do you have any other thoughts about the resistance to work requirements and why people push back on those?
I think Rich is right. You know, this is something that I think conservatives have bantered about for years, and now with the majority, they have the ability to get it through. The Democrats are always going to be opposed to that, both for TANF and with SNAP. The hope is that we would be able to continue to push back on that, but you know, we'll have to wait and see.
All right.
I agree. I think it's something that's always been a struggle, and it's always been a back and forth, and I don't see, you know, that changing in light of the fact that it could happen now as far as legislatively.
Mr. Margolin, I know when I've raised this with you before, and I can't recall if it was in this task force or at our health committee, but you made the argument, or helped articulate the argument, I should say, that the work requirements weren't really as simple or straightforward as just work requirements. That's me putting words in your mouth. I hope I did a halfway accurate job of it.
You did. It's not as simple and as straightforward. It seems reasonable, of course, to say that you should be pursuing employment and you're receiving these benefits. Shouldn't you be looking for work? That sounds reasonable. But when you actually look at the individual circumstances of many of the people on these programs, people who are challenged in various ways, low income, there may be mental health issues, family dynamics, and then you ask them to interact with government and deal with the requirements the government puts forward, you oftentimes frequently have people who should be receiving these benefits being denied these benefits just simply because of their inability to process the forms that are required, their inability to make the case they need to make as to why they deserve these benefits and can't, in fact, find work. So even though there's a rationality to the position of work requirements, the net effect of it is shrinking the size of the program and taking people who need these benefits and taking them off the program. So government spends less money. That's a Republican objective in many cases. The programs are smaller. There's more focus on self-reliance, but smaller programs reduce access for people who do need these benefits, and that's the reason why there's so much Democratic resistance to work requirements.
Thank you very much. Thank you all on that one. One last question, and a little bit different, even more wide-ranging than one of the earlier questions I asked, which is, again, you all have been doing this for a while. Many of you have worked inside these institutions, Congress in particular. The last couple of weeks have been, the last month has been, you know, it's just an intellectual matter, fascinating to watch, and I'm going to take the whole speaker drama and put it on a shelf for a minute. But I mean, I was, you know, listening to that, and I'm thinking, okay, we're looking at, you know, 4 or 5 act play here that's sort of playing out, you know, right there in front of the American people. But then just recently we had the various motions kicking around to expel or censure, you know, including the Democrats and Republicans, a range of different alleged behaviors that were, you know, going to prompt, you know, from, well, even including the fire alarm incident. I mean, it just kind of leaves you. Is the place dramatically less functional than it was 20, 25 years ago in your observation? And if so, and this is really so what? What is the bottom line consequence of that? And I know that's a pretty big topic, and I'm quite deliberately trying to give you some runway to go wherever you like with it. But I do think in talking to our constituents, talking to the folks I represent, there's quite a bit of throwing up their hands and giving up on the institution, institutions plural, and not a lot of clarity about what difference any of this makes in the lives of 2 million residents of Santa Clara County. So, thoughts?
I'll start and let my colleagues jump in. I will safely say that, when I worked in Congress, it was radically different than it is today. One of the features or one of the dynamics that has contributed to that is when I worked on Capitol Hill, for the most part, the coverage of what Congress was doing was generally done by print media, and they had deadlines at 6 or 7 o'clock at night in order for it to be published and appear the next morning. That has gone away. Everything now, news is 24/7, and also by virtue of that, every member of Congress now has a social media platform for them to become known nationally or internationally, for that matter, with their views. And there are many members of Congress now. And I would say too that even with all this, nonsense, the vast majority of members of the House and Senate are good public servants who are trying to do the right thing for their constituents and trying to, what they have the country's best interests in their heart. There are, however, a lot of these fringe players who, seek to their whole mission to being in Congress is popularity and fundraising and just getting out there. And that's unfortunate because that really distracts from the good bipartisan work that's going on. And, with all this nonsense that's going on, there is, and I mentioned this in some of the meetings yesterday, there is some good work being done on a bipartisan basis. For example, the farm, and Mr. Margolin may talk to this in his report, but the pharmacy benefit managers, the PBMs that are negotiate your drug plans, they are under fire on a bipartisan basis, and it's pretty likely that Congress is going to pass bipartisan legislation trying to split these companies up and take away some of their authorities and powers. And that's happening, like I said, on a very bipartisan basis, and that's good progress that's happening that doesn't maybe make it into the headlines because of all this other more salacious material that's making the headlines, but it's happening, nevertheless.
I'm going to, before I go to your two colleagues, and I really do want to hear from all three of you if you have thoughts to share. Smead, I want to read back to you something you just said. The vast majority of the Congress are good public servants. I know you're not a pollster. Do you think most Americans think that?
No, I don't. Because unfortunately, the image and what they see in Congress is the votes for censorship and expulsion and things of that nature. They don't really read about anyway. Like for example, we're very friendly with Josh Gottheimer from New Jersey. Josh is working his tail off to try and represent his constituents and address issues most important to them, like the deducting the state and local taxes. He's working his tail off. He doesn't get any publicity or credit for that work he's doing behind the scenes, but he's doing it. And so that's why I say most members of Congress are trying to do the right thing for their constituents. They just don't make it the headlines and don't get it. So therefore, the public's opinion of the institution is way, way down.
Thank you. Ms. Powell?
I wanted to add a bit about the motion that was put on the floor to censure Congresswoman Rashida Tlaib of Michigan. That motion was sponsored by Congresswoman Marjorie Taylor Greene of Georgia. It failed because there were some Republicans that voted against it. It wasn't because they didn't find issue with the comments that Congresswoman Tlaib had made. It failed because Congresswoman Marjorie Taylor Greene used the word insurrection in the motion. And they took issue, some of the conservative members, such as Congressman Chip Roy, took issue with that because of January 6th. That's why he voted against it. If not, she probably would have been censured.
Ms. Dorn, any comments, any thoughts?
Yes, so I would just wanted to add that from the lens of what you had said in the 15, 20-ish years ago, how it was different, in the 90s, for example, the members in the middle had a lot of power. And I feel like that has shifted, maybe because it's partly social media, partly the 24-hour news cycle, but the members on the far left and the far right get all of the airtime and all of the constant attention, and they've become the sort of the voting power or the attention grabbers, whereas as in the old days, back in the 90s, we had a lot of members in the middle, in the New Democrats, the Blue Dogs. There were members who were pro-business Democrats in those days were unusual, and they had the power. And so I feel like there's been a big change and a big shift in that, and somewhat inexplicable, I guess, but that's the attention is on the fringe.
And one other factor I should also mention is gerrymandering, right? So it used back in the 90s, you had lots of members of Congress from what we call swing districts. Either Republican or Democrat could probably win the district. The state legislatures that draw their own maps have a tendency to draw, very, very red and very, very blue districts, so that these members of Congress don't really have a threat of losing their general election, but do have a threat of losing to a primary, which drives them to right and left, unfortunately. And that's just both sides of the aisle are guilty of drawing the maps these ways, I believe.
All right. Let me check with the clerk, forgive the cough, to see if we have anyone who is queued up to speak on this item.
There are currently no requests to speak.
Thank you. Unless there are other questions or comments, Supervisor Lee, I think we should say thank you to the panel for now and simply ask for motion to receive the report.
Yeah, I think before I make the motion, I just want to say thank you so much for being here today. Really appreciate you coming here in person to present this very important update of what's going on in our federal government, which is, of course, extremely convoluted. Answering some of the questions that's been asked by my colleague about this 25 years ago difference, I would reference back to 1994. Back then, there's a speaker named Newt Gingrich, and I think that contract on America has a lot to do with this dysfunction, if not just good old open warfare. And this is not just between Democrats and Republicans. I'm talking about within the Republican Party, for example, that we've seen, which is truly unfortunate, and how the extreme sides of the party has now, like you say, dominate the airwaves, control the dialogue, and with the news cycle the way it is right now, that becomes the new normal, which of course I don't think is healthy for democracy. And certainly the word compromise, which is so important to get things done, has become a bad word. Right. So on that, I so moved to receive the report. Thank you.
All right, we have a motion to receive the report on item number 6. I will second. I will add my thanks, and clerk will call the roll.
Aye.
Chairperson Simitian.
Aye. Motion carries unanimously. Thank you very much. It takes us to item number 7, which is the report from the Office of the County Executive relating to federal health policy and budget landscape. Mr. Campos, do you have introductory comments, or do you want to pivot straight to Mr. Margolin?
Go straight to Mr. Margolin, and of course we will follow up on a number of requests that were made on the prior item.
Thank you for duly noting that. Mr. Margolin.
Yes.
How are things in the healthcare world?
Challenging as always. Let me begin by making a comment on the new speakership in the House, and start by saying that Mr. Meade did an excellent job of summarizing the dramatic events over the last several weeks and the emergence of the new speaker, and I agree with almost everything he had to say. The only point I would make of small difference, perhaps, is the prospect for a government shutdown. I agree with his assessment that Speaker Johnson is committed to a CR, and it's not likely that we'll have a shutdown. But I wouldn't. I'm not sure I would say that the prospect is low until we know more about Speaker Johnson and how he performs as a negotiator. He is, in the modern history of the Congress, the most inexperienced and untested person ever to emerge as Speaker. And we don't know how he negotiates. We do know that the first sign of his performance in this regard is the Israel aid package, where he did attach as a rider this cut in the IRS funding that was approved by the Congress last year. And this is something that the president won't sign and the Senate won't accept. And perhaps Speaker Johnson put that in there just to sort of test the waters, and being a skillful negotiator, he'll ultimately drop that request. But we haven't seen that happen yet. And we don't know whether the far right of the House Republican caucus will demand in any CR that might emerge this month similar kinds of riders, and how stubborn or intransigent the Speaker will be about insisting on riders that are non-starters with the Senate and certain to be vetoed by the president. So again, I'm cautiously optimistic that, as Mr. Mead is, that we'll end up with a CR and there won't be a government shutdown. I just think that that was so little known about Speaker Johnson as a negotiator. There's maybe on my end a bit more risk out there than has been spoken about. On the health policy side of the equation, let me talk about Speaker Johnson and make a few points that I think are worth us all paying attention to. Speaker McCarthy was very conservative, we know that, but he was also not especially steeped in the intricacies of policy. That wasn't his area of focus. He was much more political and transactional. Speaker Johnson comes to the speakership having worked professionally for many, many years as an advocate for a range of very socially conservative positions, with opposition to abortion being a particular preoccupation for him. This is the first time in the modern history of the Congress that we have somebody this strongly ideological with these kinds of views who has, prior to election to Congress, worked professionally as an advocate for these views in a top leadership position. So how that plays out, this goes once again to how flexible he'll be in negotiations. We don't know for sure. He comes across as reasonable, and he's well liked by his colleagues, and this all may work out well, and he may, as Mr. Mead suggested, put aside his personal views in the interest of compromise. But again, it's untested. We'll have to wait to see. Going back, talking a bit more about his background prior to being a member of Congress, he was the senior counsel for the Alliance Defending Freedom, one of the organizations that they pursue legal strategies against abortion and other issues, and they were part of the Dobbs case, which overturned Roe v. Wade. And when he was working for the Alliance Defending Freedom, Speaker Johnson actively worked to shut down abortion clinics. His views on this issue are very hardline, so we'll have to see how that plays out in his new role as Speaker. As a member of Congress, he has co-sponsored numerous bills to outlaw abortion after fetal heartbeat is detected, usually around 6 weeks. So it's worth noting that as well during his tenure in Congress. On the ACA front, there's some history there to look at. It's obviously fairly standard for almost every Republican to argue for repeal of the Affordable Care Act. That's not unusual. But he seems to have gone a bit beyond just being for repeal in that 2017-2018 period when that was an active issue with Trump as president. In 2019, when he was the leader of the Republican Study Committee, the conservative caucus in the House for Republicans, he signed a report put out by the Republican Study Committee, which had a number of recommendations regarding the ACA. First, it directly attacked the pre-existing condition protections in the ACA, arguing that they added to the cost of insurance and were bad policy. He then went on, in this report then went on to call the Medicaid expansion a failed policy, even though it is now adopted by 40 states, and called for it to be phased out over time by withdrawing the enhanced federal match that has made the subsidy and the expansion an attractive feature for these 40 states. If you take away the enhanced match, you ultimately reduce the number of states that want to be in the expansion, and at some point it doesn't exist as an expansion. The report also advocates a per capita cap. We've talked for Medicaid. We've talked about that in the past. If you subject Medicaid to a per capita cap, then states have no choice in most cases to either reduce eligibility or cap benefits in order to live within a per capita cap. So these are views that were expressed in 2019 when the issue of repealing the ACA had died down, at least on the part of most Republicans. So he has very strong opinions on this. And I would say in general, he is not a blank slate in the area of healthcare. He's a blank slate in other areas. He's brand new to leadership, but we know his views, and we know that to the extent he decides to act on those views, it will provide a challenge for the issues that Santa Clara County cares about in the healthcare sphere. The last item I want to just note here, and this goes to also to a point Mr. Mead made about bipartisanship. He talked about pharmacy benefit managers, the PBMs, and how there's bipartisan concern about that issue, and there certainly is. It's worth noting that Senator Padilla, our own California senator, recently formed the first ever Senate Mental Health Caucus on a bipartisan basis. Padilla, Tillis, Smith, and Ernst, those four senators were the founding members of the caucus. All these members have some kind of personal engagement with mental health issues within their family and are deeply committed to this work. And again, they are all over the map ideologically, but they came together. And going back to the point about why Congress is so poorly viewed by the American public, all of the machinations involving the speakership race get a lot of attention. Every time there's a Marjorie Taylor Greene provocative tweet, it gets major attention. When Senator Padilla puts together this bipartisan caucus, it's not front page news. And that's part of the ongoing dynamic we have to contend with, even though in my view, and I think in the view of most of us, it would deserve to be front page news. The initial work of this caucus is going to be to monitor the implementation of the Safer Communities Act, which was passed following the Uvalde, Texas mass shooting. It has within it, this act, $60 million in funding directed at providing mental health awareness training for school personnel, first responders, and law enforcement. And this bipartisan caucus wants to ensure that the money is spent effectively. So that completes my report. Happy to respond to questions.
One just quick question, only because I couldn't keep pace. The four members of the bipartisan mental health caucus, again, I know Senator Padilla is a lead, and I heard you say Senator Ernst, and forgive me, I just missed the other two.
Oh, that's all right. I did go quickly at that point. Senator Tillis and Senator Smith. Tillis, a Republican, Smith, a Democrat.
All right. I do not have additional questions or comments. Supervisor Lee?
Yes, this is the first time I heard about the Senate Mental Health Committee. Very exciting. So if anything coming up, please give us post some signal, and thank you so much. And then second thing is we mentioned the Safer Community Act, the $60 million. For Congress, that's a very small drop in the bucket when it comes to how serious this issue is regarding the mental health issues around the country. So, and do you see that money, like at least a little bit of it, how is that being distributed to us?
So I'm not familiar with the details of that. I'd be happy to get back to you on that. Again, the Mental Health Caucus in the Senate has said that they're going to monitor distribution. Again, I will learn more about the methodology and be happy to share that with you.
Thank you.
Thank you. And I will just indicate no reason our Mr. Bargolan or the team from Prime should know it, but I had the pleasure and privilege of serving with Senator Padilla when we were both in the California State Senate. Hold him in high regard, a serious person, and to the comment, Mr. Margolin, about what is or isn't front page, sure enough, I noted the story, I think, in one of the two daily newspapers, the Chronicle or the Mercury, and I think it was on page 7, if I remember correctly, buried below the fold. So, thank you. I think that's actually a little bit of it gives a little bit of hope, a glimmer of hope that folks can tackle important subjects on a bipartisan basis, notwithstanding the tumult and that we sometimes are obliged to note. We don't have speakers on this item?
No speakers.
All right, then I'll ask Supervisor Lee for a motion to receive the report.
So moved.
I'll second. We'll ask the clerk to call the roll.
Vice Chairperson Lee.
Aye.
Chairperson Semidian.
Aye. Motion carries unanimously. Thank you, Mr. Margolin. And that takes us to, I believe, item 7. 8, forgive me. These are the higher math skills of the day, which is to receive report from the Office of the County Executive relating to the Federal Aviation Administration Reauthorization Act of 2023. And this may involve a little local history for the Prime team as well, and maybe even a little storytelling. Mr. Campos, what do we know?
Thank you, Mr. Chair. And before I get into the specifics of that, I do want to note, just the whole discussion of what's happening in D.C. and the future with the new leadership in the House of Representatives. We are, cautiously optimistic and hope that Mr. Meade is right in terms of his assessment of the speaker, the new speaker. But we do actually share the concerns that have been outlined by Mr. Margolin. Not only his history as an advocate against rights around reproductive rights, but also LGBT rights, a long history of targeting that community and trying to criminalize some of that conduct, and some of the steps that we have seen where you have seen things, some of the first actions actually respond to what the more conservative members want, which is to couple Israel aid with spending cuts. And that's one of the reasons the SNAP issue is so scary, because you have 41 million Americans that will be impacted by that. So we'll be watching that and keep you informed and hope for the best, but we certainly will do everything we can to ensure that the rights of our residents are protected. With respect to the FAA reauthorization, there's a written report where we highlight 2 issues that we wanted to make sure that you were aware of that we have been working on as IGR. One of them is the issue of airport noise. And as you know, this is something that has been a priority for this board and members of this committee for quite some time, and simply reporting that the bill that was presented in both the House and in the Senate, from our perspective, did not go far enough to address the issue of noise. We note that our delegation was very outspoken on that note. There's a letter that we sent to Representative Eshoo commending her for her efforts to enhance the responsiveness to that issue. The bills, as they currently stand, don't really go far enough from our perspective. But we just wanted to note that this is something that we're going to continue to watch and continue to push to make sure that the issue is more adequately addressed. The second point has to do, in terms of FAA reauthorization, what's happening with the issue of leaded aviation gas. As you note, as we note in the report, we in Santa Clara have been leading on this issue, becoming the first jurisdiction to ban the sale of leaded aviation gas at our 2 airports, general aviation airports. And I'm going to turn it over to Aaron and Prime to discuss sort of where that is. And I want to note that there has been a lot of work, not only with the Prime team, but also our county council team. We have Jarrett Yan here, who has been working closely with us on this, as well as Deputy County Executive Sylvia Gallegos. So I will turn it to Aaron to give you a brief update on where that is at this point.
Thank you.
So I'll just set the stage for what has happened to this point, and sort of the moving pieces. Last week, Michael Whitaker was confirmed as FAA Administrator, a position which had been vacant since April 2022. Whitaker was confirmed by a 98-0 vote in the evening of October 24th. The leaders, Schumer and McConnell, prioritized that confirmation, given that the acting administrator would no longer be in that position as of October 25th. The new Speaker, Speaker Johnson, indicated in his first week as Speaker that the passage of an FAA authorization bill would be a priority for this Congress. In an early memo, he indicated that the House would begin negotiations on the FAA reauthorization as soon as the Senate passes it. You'll recall that the House passed their version this summer. The Senate, however, the Senate's FAA bill remains stalled before the Senate Commerce Committee, where Chair Cantwell and Ranking Member Cruz have been unable to break the logjam as it pertains to the 1,500-hour pilot training rule. Senators Thune and Sinema continue to seek a compromise on allowing additional flight simulator time as an option for trainees to reach their 1,500-hour requirement. Leader Schumer and Senator Duckworth, who's the chair of the subcommittee, have effectively blocked the advancement of the FAA bill until Senator Sinema and her GOP colleagues drop the 1,500-hour issue or infinitely walk that proposal back. There's hope that Administrator Whitaker will be able to broker an agreement on the Senate between both sides of the issue, both sides of the aisle. But that still remains to be seen. The FAA's authorities expire on December 31st. Given the limited remaining legislative days in the Senate, the lack of progress on the bill itself is nearly certain that another short-term extension will be necessary. As a reminder, the Senate had previously negotiated a shorter extension, 3 months instead of 6, with the hope that the chamber could prioritize the issue in Q4 currently. But unfortunately, there seems to have been no progress made to this point. Several vehicles could help carry a short-term extension, including government funding or whatever passes prior to November 17th. Should Congress decide not to include an FAA extension in their November funding vehicle, whether it's CR, SCR, or otherwise, there remains broad support for continued FAA extensions, and no lapse is expected should the Congress need to pass an extension on its own merits in late December. So while the timeline for a long-term extension of FAA's authorities remains unclear this Congress, the window to include meaningful policy changes in the Senate's bill is narrow. The vast majority of FAA policy issues have been resolved before the committee, and stakeholders who wish to amend the underlying FAA bill should strive to work with both Senators Cantwell and Cruz's professional staff, to ensure that they're educated on the issues and win commitments to work to make changes on the floor.
And if I may just add a couple of points for those that may be watching. Essentially, what's happening with the two versions of the FAA authorization bills is that even though they have differences, they essentially prohibit jurisdictions like Santa Clara from doing what we're doing, which is to no longer sell leaded aviation fuel.
Let me just ask you to pause for a moment, because this is going to a question I was about to ask. So Let me insert the question in your comment,
yes,
if I may.
You.
And that is, on the one hand, the federal EPA, as I understand it, issued an endangerment finding middle of last month, I think. On the other hand, it's not clear to me how, if at all, the finding comports or doesn't comport with the language that you're now referencing, which sounds quite troubling. And I guess my question is there any update on the ability to engage with the Senate on this leaded avgas issue?
Sure. Thank you for your question, Mr. Chair, and I would also welcome Mr. Yan if he wants to add to this. But essentially, in June, both houses submitted their own version of the FAA reauthorization bill. Even though there are technical differences, in essence, each version would prohibit a jurisdiction from doing what Santa Clara County has done. We are very grateful to Congresswoman Lofgren and to members of our delegation who fought hard to change and amend what's in the House bill. But from our assessment, given that this is a Republican-controlled House, we decided that our best option was the U.S. Senate, which is why we proceeded to work closely with Senator Padilla. And to your earlier point about Senator Padilla, he immediately responded to our request and is doing everything he can to amend the Senate bill where we think that we have the best chance. Unfortunately, he's not a member of the committee where this happens. We are trying to do everything we can, working with his office, to convince the chair and the majority lead on that, the Republican on that committee, to make the necessary amendments. We're also working closely with the staff of that committee who understand the issue. Last, hope would be that on the floor of the U.S. Senate, we make the necessary amendments. So again, doing everything we can to make that change happen, and Senator Padilla has been extremely helpful with that. In some respects, this lack of an agreement on the separate issue of training has actually worked to our benefit, because so long as there is no resolution of that issue, it means that there is no bill that will be passed, which then allows the status quo to continue. And if there is a continuing resolution that extends the FAA reauthorization, that actually means that Santa Clara County will be allowed to continue to do what we're doing. So in that sense, the logjam, if you will, has worked to our advantage. In terms of the EPA funding and the FAA actions and the actions by the Congress, absolutely, Mr. Chair, they are inconsistent, but I will turn it to Mr. Yan to speak more about that specific question.
So as you noted, the EPA did make an endangerment finding a few weeks ago. This is a result of a petition that the county filed in August of 2021 that the EPA initiate a rulemaking under the Clean Air Act to regulate lead emissions from avgas. So this is a two-part rulemaking. The first part is to find that that lead emissions from avgas endanger public health and welfare, which is the finding that the EPA did make. And the next part will be for the EPA to actually make emission standards on lead from avgas. So as you note, this is kind of the federal government moving in two different directions. The EPA is pushing for regulations. The Congress is pushing in the other direction. And I think we've taken this as an opportunity to highlight for a number of members of Congress that this is an issue that the EPA is working on, and that Congress shouldn't be taking us backwards. I know that Representative Lofgren is putting together a letter to colleagues. I think she's been working with Senator Padilla to make it a bicameral letter. We're working with our allies, Earth Justice, and a number of other community-based organizations to really use the endangerment finding to highlight the issue of the dangers that lead from avgas poses.
Just last point of information to you. In addition to the work that we have been doing with our delegation, with Senator Padilla, we also have been trying to influence public opinion on this issue. We actually drafted a number of editorials, opinion letters to various newspapers. In the end, nothing was published, but we're happy to report that there was actually an editorial in the LA Times that addressed this issue. So we are cautiously optimistic that as more public attention is given, that people will see the very real concern. And again, in terms of history, leaded fuel has been banned. Lead has been banned from automobile gas, from paint, and yet this is the remaining industry where you have lead still being present, and in neighborhoods like ours here in East San Jose, creating a lot of danger to the community, and we need Congress to act. And so we will keep you posted and are grateful to Prime for helping us navigate this.
Thank you. I do want to encourage the continued engagement with the Senate, and I took heart in noting that the training dispute, if you want to call it that, has actually given us a little time and a window of opportunity. I also want to ask, however, that you take this opportunity to engage on the issue of airplane noise, airport noise, a little more robustly. For the folks at Prime, this, and I'm going to look to my own staff, Ms. Zanardi, who's here in the chambers, I think it was back in 2016, if I remember correctly, we had a select committee on airport noise, and I think the proper title was the Select Committee on South Bay Arrivals, and was convened at the behest of then Congressman Sam Farr, then Congresswoman Jackie Speer, and Congresswoman Anna Eshoo, and we spent, I don't know, the better part of 6 months in hearings with literally, hundreds and hundreds and hundreds of folks in 3 different counties, San Mateo County, Santa Clara County, and Santa Cruz County, on the issue of airplane noise. I will tell you that while it is not an issue for a great many folks, for the folks for whom it is an issue, it's a big issue. And I think you could, that may be one of the only ways I would compare it with the avgas issue. I think there are a lot of people sort of say, not my world, why would I care? But for people who are proximate, it's a big deal. I have to say, candidly, I have become jaded. That's the kindest word I can use about the interest of the FAA in responding to legitimate concerns, and I want to underscore that. These are not just folks who are grumpy because an occasional airplane flies by. Legitimate concerns about how they chart arrivals in a very challenging environment, which I'd be the first to acknowledge, given SFO and San Jose and Oakland and around our bay. But if we miss the opportunity to use the reauthorization for engagement, I feel, regrettably, pretty certain that in the subsequent years, the FAA will have no interest whatsoever in tackling this issue. They really look at noise issues in a way that is unrelated to facts on the ground, so I'm just going to ask that we, while we're at it, let's take this opportunity to see if we can get even a little bit of progress, some acknowledgement or willingness to tackle these issues in the future. I suspect the folks at Prime are familiar with the so-called Quiet Skies Caucus. Everybody's got a caucus. The Quiet Skies Caucus is there. It is, unfortunately, in my view, a little smaller than it could be, should be, and I think that's part of the challenge, is that just aren't enough members who take this issue on. Supervisor Lee and I have different districts, obviously, and we have different impacts, but we both have some familiarity with airplane noise and noise from South Bay arrivals and departures. So I'll just ask for that item. Supervisor Lee, anything else on this item? Please.
No, I just want to say thank you for the continuing work on this issue. We certainly have served as a leader on this issue of not using leaded gas anymore. It's since the 70s, and that's almost, 50 years ago we're talking about, that we have already not allowed the leaded gas in our cars. The fact that this still continues in our aviation industry is certainly shocking in many ways. So I hope that we'll be able to keep doing that and not get backwards regulation to not allow us to do what is right for our community. If anything, we should be setting example and not exception to this. So I just want to say thanks for continuing on that very important issue. It's interesting to also see that this training issue is so important. I mean, I think people understand that using simulator will save money, obviously, than actual flight time on the air. But of course, in terms of training safe pilots, I think there really is no substitute to being up in the skies, really feel turbulent. So I think this is the right thing. And Senator Duckworth is an old friend of mine, and she being a helicopter pilot in Iraq, knows a lot about flying. She can fly anymore because she lost both legs in the crash. In any case, I certainly do think that that would be something good to continue. Certainly does not hurt the pilots to have additional time on the simulators, but I think that requirement is something that's useful. I did see something somewhat interesting on the side note. It says something about how Speaker McCarthy blocked a vote on the amendment to maintain the current pilot retirement age of 65 on this act, which has something to basically allow pilots to fly older. And there was some reference saying how that might have something to do with the fact that his brother could then fly for a couple extra years. I thought that was just interesting side note I saw. Thank you.
I think, unless we have speakers on this item, and I'm looking to the clerk who
There are
tells
no
me we do
speakers.
not, thank you, that we have covered these items. Can we get a motion to receive the report?
Yes, so moved.
All right, we have a motion to receive the report. Again, I'll exhort our team to stay on it, both with respect to the avgas issue and also the FAA's engagement or lack thereof with respect to airplane noise. And we have a motion by Lee, a second by Simidian. Call the roll.
Vice Chairperson Lee.
Aye.
Chairperson Simidian.
Aye. Motion carries unanimously, and we have, I think, completed our agenda. So without objection and hearing none, we will stand adjourned. At present, our next regularly scheduled meeting is Thursday, February the 8th in these same chambers at 10 a.m. Thank you all for being here. Nice to see our friends from Prime here in person. And Mr. Margolin, always good to see you, virtually or otherwise, sir. Take care.